All right, Mr. Gamble.
Your Honor, we close evidence, we rest.
State the defendant rests. Mr. Lamb, do you have any rebuttal evidence?
No, Your Honor.
Okay. My proposal would be for us to have a jury charge conference, all the things that we need to do in preparation for y'all to give closing arguments, and that y'all start your closings in the morning.
That would be great, Your Honor.
I think that'd give people plenty of time to prepare. Ladies and gentlemen, the evidence portion of the trial is completed. There's a good bit of work that I need to do with the lawyers. They get to go over the charge that I'm going to give you and make any objections, and we work that out. And also, I want to give the attorneys time to prepare their closing statements so that they can have overnight to actually get their thoughts in order. It's very important to both sides, and I want them to be able to narrow down their thoughts and give a good cohesive argument. So I'm going to recess for the afternoon as far as you're concerned. I would like you to return at 9 o'clock in the morning, and at 9 o'clock we'll bring you in and we will begin the closing argument phase of the case. All of the instructions that I've given you are still in place. You'll begin discussing this case once I've given you my final jury instructions in the morning after closing arguments. Okay? So with that, you are excused. Please don't look at that TV or that internet tonight, okay? Watch a rental movie. Yeah. Well, you can still rent a movie on TV, right? Yeah. Yeah, why don't I send y'all the draft of the charge? I've got some corrections already written on it, but y'all can look it over. It's basically a combination of both of y'all's. We'll come back over and we'll go over that charge conference.
We will need to add, I did not put the charge in about if a defendant does not testify.
Okay.
I mean,
Yeah,
I didn't know which one it'd be, but obviously now it needs to be.
All right.
I think we can also remove all the charges that we submitted on
I noticed all the charges about
police
voluntariness of the statement.
right, police interviews, yes.
Yeah.
Those can all be removed.
Okay. So go back those two revisions and then send it to both of them. Y'all got your computers here, right?
Yes.
Okay. And I'll come back at 3:30 and we'll go over that charge.
Okay.
I think so. That's my preference if we're able to.
You do in other cases, I'm just making sure.
No,
Oh, okay. I'm sorry.
I didn't.
Thought you were talking to me.
I didn't know if you were here. Someone trying to interrupt you.
Mr. Lamb, have you reviewed the charge that Mallory just sent?
Yes, sir. And
I'm going to make some grammatical changes, like take out parentheticals and eliminate things that are not applicable. But we'll, in general, are there any that you believe need to be added or stricken?
I don't recall anything that I don't think I guess the charge 13710, character of the defendant. I mean, he says it's not character evidence; it's evidence to show that she had great child care skills. That's a different thing than character evidence. So I think that that charge should probably be removed on page 6.
Mm-hmm. Well, it's on my page 5.
Okay. Well.
Mm-hmm.
I think when I redid it, now it's on
Oh,
page 6.
okay. So you're asking that one be removed?
Yes, sir. I don't think it relates to anything that is in evidence in this case. the defense has asked, as I understand it, the defense has asked for the long version of the direct circumstantial charge, and the state concurs with that.
Okay.
I do not. I mean, I don't have an objection to it. In fact, I prefer it. The long version
okay, yeah,
of the
yeah,
circumstantial
yeah,
evidence
I got you.
charge.
It just makes, it describes it that
As you can guess, I usually give the short one, but
well, I know. And I do sometimes in certain cases, but I think this has a little better description, Your Honor.
all right. I'll take out the short one and give the long one.
I don't think there's. I don't have any other objections or comments, I suppose, at this point.
All right,
No,
Mr.
sir.
Gamble.
Nothing else.
Yeah, and I've reviewed it, and with that notation you've already made about the going with the long version instead of short, that was the only real comment I had. I don't really object if you take out the character objection. I don't think it really matters much one way or another to me.
Okay.
And the only other thing I would have is Mr. Lamb and I both discussed it. He brought it up, but the news cast that I used to question Mr. Wright about it, we've got on a flash drive, not to go out to the jury, but needs to be, we think, marked as defendant's exhibit 4, and made a part of the record.
And the state, and the state has no objection to the
It'll
court
be admitted.
reopening the evidence for the submission of that. And I would also, Your Honor, ask at this time, according to our records, all of the state's exhibits were in fact tendered and admitted. I mean, there were a couple of them that were admitted not to go out with the jury, but they were all tendered and admitted. I believe if anyone has any different information on that, I would ask that we be advised of that, so that if I need to make a motion to reopen briefly, I could do so.
All right, let me find my list. My recollection is that everything.
Yes, it's empty for you to load. Yes.
Okay.
Yeah,
Yeah, I got thinking you don't have it. I was
no,
thinking
we have some extra blankets
Thank you,
over
thank
here.
you. Okay.
All right, so I'm going to allow the evidence to be reopened, and 4 will be admitted,
Yes, you are.
but it will not go out with the jury.
Correct.
And I think we can just do that by stipulation, unless you want to do it in front of the jury.
No, yeah, I
Okay.
don't. I don't need
No,
for it.
I think that the
It's confusing.
right. I think that
Because it's not going out with the jury anyway.
Right, it
when
confuses
you tell them that you're sending the evidence out with them, we send them the stuff that we're sending them, and then
Okay.
that's my view.
Yep, I'm good with that.
All right, but
And-
let's make sure we're all on the same page while we're at this as to what does not go out with the jury. I believe the videos would not. I mean, they may ask to see them, but we customarily will not send it out with them. So that's exhibits 20, 21.
Exhibit 3.
What'd you say?
I thought I have 23 as a picture.
No, number
3,
3. Okay.
3, 20, 21.
Wasn't there a written statement that y'all?
The coroner's statement, whatever it was.
Yeah, that's what I was thinking.
I know it was.
That's 40. Exhibit 40.
Yes, it's not.
Okay.
That would not go out. That's subject to the continuing witness rule. I think. Did you put the article that you used for impeachment? Did you put that in to evidence?
It did not go into evidence.
It was not. It did not. Okay.
Oh, you mean the treatise?
Yeah.
Yeah, I think the rule says you can read it into evidence, but you can't send it.
Right. You can, that's what I'm saying. I mean, if it was
It was
admitted,
not admitted, and I don't think it needs to be.
I don't think it has to be. But if it were, then it would not go out.
Yeah, it doesn't.
The medical records, I don't think are subject to continuing witness because they're not actually statements. They are
I think they can-
summaries of actions.
I think they're admissible. And then the only other one that won't go out would be Exhibit 4, the news. So it's prosecution exhibits 3, 20, 21, and 40, and defendant's exhibit 4 will be the only ones that don't go out with the jury. So I will go back to my desk, and I'll make some minor changes to the, maybe even the order that they're given. Like at the end, I like to conclude with the one about deliberations. Well, she's already done that.
What about a verdict form, Your Honor?
That's the next thing I was gonna ask. You want us to prepare a verdict form?
Doesn't the court have a law clerk?
That was us. I definitely said us.
Yes. No, I mean, I certainly have no problem.
Okay.
with
All right.
the
And
court
Sherry's got
preparing.
a good form for it too. So we'll get the verdict form. We'll send that to you before I leave today. I'll make some minor changes. This one change I noticed was on stipulations.
Yes.
I thought maybe the first paragraph, but I couldn't really see how I would give the second.
Well, there weren't any stipulations.
There was some stipulation about.
There was the only stipulation was as to the admissibility of Exhibit 26, but it wasn't a stipulation as to a fact. It was simply
that it wouldn't go out with the jury.
Well,
that's right.
it was just a stipulation that it would go into, that it would come into evidence because it was tendered under a certificate, pursuant to notice.
Okay.
And so, I think
I think that's accurate. So, do either of you request this charge on stipulations?
Well, I did only because I did know that we did do a couple of stipulations. They may have been on some minor issues, but that was why I put it in.
I mean, I think if the only stipulation is as to the admissibility of evidence as opposed to a stipulation to a fact, then I don't think that the stipulation charge
and
is necessary.
I mentioned stipulation in another part where I tell them what the evidence is. So my inclination would be to take the actual charge out.
No objection from me.
Well, I just note the second paragraph talks about where parties stipulate, and then it says testimony, documents, exhibits only. This is in the nature of evidence. You may take that testimony as if it was given in court. You may rely on it if you find it credible. However, either party may dispute such testimony by other evidence. I don't know. I thought that part might need to be in there, Your Honor, but I'm not.
Well, it's not going to hurt. I mean, if you're requesting it, I'll put it. It's
I would
definitely not.
I would just request that part.
All right, I'll give the
So
second.
you're just not going to give the first paragraph of
Yeah,
that?
I'll give the
first paragraph
second.
of reading
Okay.
doesn't make
I'll
any
give-
sense
I'll
to
give
me.
paragraph number
I
2.
look at it, it does not apply.
Sure.
I think.
All right. Okay. Well, I'll send that to you all, and then we'll start closes at 9 o'clock. Y'all get here early enough to check your computers and all. Looks like y'all got yours. Y'all are just using the same portal at this point. Is that
We
right?
are, yeah.
Yeah. Okay. Anything else we need to address before closing arguments in the morning? Okay.
Nothing that I can think of. It's 2 per side, right?
2 hours?
Yes, sir.
Yeah, you each have 2 hours.
I mean, I don't think I'll talk 2 hours. I never do that, but
Well, I mean, we have all day, so I'm
I
not.
wanna have it
you know,
available, though,
If
so.
any of you want to speak for 2 hours, you can.
yes, sir. Understood.
Of course, you'll get to open and conclude. What I would like to do, if we start at 9, I guess we'll see when the closing arguments finish. I might send them to lunch, let them come back and then charge them, or I might charge them and tell them they can ask for lunch whenever they want to. I just have to kind of play that by ear.
Understood.
Or even offer to get them some pizza and let them work through lunch or something like that. We'll see how all that works. All right. Thank y'all. I'll see you in the morning.
Thank you.